When is it legal to use a firearm in self-defense? Now, this is a very complicated answer, but I'm going to do my best to make it easy for you to understand. Florida Statute 776.012 subsection 2 is known as the Justified Use of Force statute. This statute lays out the framework for when we are allowed to use or threaten the use of a firearm in the state of Florida. Here's what the statute says. A person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself or another, or to prevent the imminent commission of a forcible felony. A person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat and has the right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in a criminal activity and is in a place where he or she has a right to be. Before you can truly understand when you can and cannot use a firearm in self-defense, we must dive deep into the true meaning of several key words found in Florida Statute 776.012 subsection 2. What does reasonable belief mean? Have you ever heard the term, "I was in fear for my life"? Gun owners love to throw this phrase around as if it's the checkmate. These individuals believe that as long as they are in fear for their life, they have a legal right to use a firearm. However, just because you believe your life is threatened doesn't necessarily mean that that opinion would be shared by the police, the prosecutors, a judge, the jury, or the public. The term reasonable belief must be applied objectively and subjectively. So not only do you have to believe that you're going to die within seconds, but a reasonable person, who's the jury, would have to look through your eyes to determine if, given the exact same set of circumstances, they would have used the exact same level of force. If looking through your eyes, they would say, you know what? If I was that person, I would believe that I was about to die. I want you to imagine for a second that you're walking down the street when all of a sudden somebody walks up and pimp slaps you. Now you may truly believe that you're gonna die from a slap, but would a reasonable person believe you are gonna die from a slap? I don't think so. What does imminent mean? Many firearms owners and concealed carry permit holders have a false belief that they're gonna have a 5-minute long decision-making process of when they're allowed to use their firearm in self-defense. This is very far from the truth. Dictionary.com defines imminent as likely to occur at any moment, impending. The term imminent does not apply to your fear of death in the next 30 minutes, 10 minutes, or 5 minutes. It refers to the fear of death of yourself or somebody around you within seconds or at any moment. If a crazy man is threatening to stab you, but he's 100 yards away, are you really in imminent fear of death? How long is it going to take for that bad guy to get close enough to you to actually hurt you? It's going to take a few seconds, and those precious seconds give you the ability to get away. Great bodily harm. The state of Florida does not provide a statutory definition for great bodily harm. However, a Florida court describes great bodily harm as more than slight, trivial, minor, or moderate harm, and as such does not include bruises. Heck versus State. I would interpret great bodily harm to mean a very serious injury, like cutting off a limb, breaking a bone, permanent brain damage, or permanent disfigurement. Again, this is just my opinion. A forcible felony is any of the following 16 crimes: treason, murder, manslaughter, sexual battery, carjacking, home invasion robbery, robbery, burglary, arson, kidnapping, aggravated assault, aggravated battery, aggravated stalking, aircraft piracy, unlawful throwing, placing, or discharging of a destructive device or bomb, and any other felony which involves the use or threat of physical force or violence against any individual. You can find the definitions for these forcible felonies inside of my book, Florida Concealed Carry Law. If you haven't picked up your copy of this book yet, you are absolutely missing out. I'll include a link below for you to order a copy of my best-selling book right now. Let me ask you, how much time are you going to have to make a decision in one of these situations? It is going to be a microsecond. So when should you decide when you're going to use your gun, but more importantly, when you are never going to use it? You need to think about these situations today as you are playing the what-if game. You need to start thinking about all the different situations that could potentially happen to you and where that line in the sand is that gives you a right to use your gun. Because in the heat of the moment, you are going to be making bad decisions if you are not prepared. Think about your daily routine and the environments that you are typically in. What types of situations are you most likely to be exposed to? Once you create this list, determine where the line in the sand is. What does that bad guy have to do before you are legally allowed to use or threaten the use of that gun? Earlier, I shared a story of the man that attempted to stab me. Everything that I did in that situation was subconscious. I saw the weapon immediately because I always look at people's hands. I knew I had a right to use deadly force because I've studied and memorized the law. So I drew my firearm without consciously thinking about it. This should be your goal. However, it does require training.